She's resource. Is Linda Altenhoff a resource, or?
She's a resource. She's my dental officer.
Do you want her up here? She can come up.
I know not right now.
Okay. Go ahead and state your name, who you represent.
Sure. Good afternoon, Madam Chair, Mr. Vice Chair. I'm Douglas Wilson, Inspector General, Health and Human Services Commission. Good afternoon, Sunset Advisory Commission. On behalf of the OIG and all of my hardworking staff, I'd like to thank the Sunset staff for their work identifying the areas where OIG needs to improve. We appreciate that this important task was approached with thought and professionalism. The purpose of this report was not to know what we do well, but to point out areas where we are lacking and offer recommendations for improvement. We take this report and its findings seriously. There is no question there are areas that we must improve on, and we'll begin working on many of the issues addressed in the Sunset Report. During the last 2 legislative sessions, I was transparent about the challenges facing the office. I took over an agency that was not very effective or efficient by any measure. In the last 4 years, we have developed new policies, new procedures, implemented new training, and essentially rebuilt the entire office. We work diligently to implement practices consistent with the rapidly changing federal law and its requirements, as well as the stricter requirements of Texas law. At the same time, everyone recognizes there's continued room for improvement, ways to make the investigative process fairer, more efficient, and more effective. The OIG also recognizes the legislature ultimately determines how the office should operate. We also recognize one of the greatest areas for our improvement is in communication to the public, in provider outreach, and in education. By providing a more public and open view, we believe OIG can work with the programs to assist with prevention efforts, which will impact our post-event recovery efforts. OIG is responsible on behalf of the taxpayers of Texas for ensuring that the money spent on health and human services is done so wisely, only when needed, and to recover any funds found to be misspent because of fraud, waste, and abuse. We are ready to work with the Sunset Commission and the Texas Legislature to support and enhance our mission, and I am confident that OIG will do what is needed to reach that goal. We look forward to the opportunity to explain further, learn more, and continue to evolve along the lines the legislature deems most appropriate. That concludes my comments, Madam Chair, and I'll entertain any questions you may have.
Representative Raymond.
Just a couple of things. Well, let me yield to my senior colleague, Madam Chair, and then I'll... Harold, you want to...
Oh, go ahead, Richard.
All right. Just a couple of things. You know, you were sitting here, so you've heard me mention that, again, I want us to do the job right, and I don't want us to be, to do wrong to folks out in the private sector while we're trying to do right. But I want to give you an example another member in the House brought to me in dealing with your office. So I'll get as specific as I can. He had constituents who came to him and said, once service that they provide was covered by Medicaid, they went to Health and Human Services, said, all right, this is what we're going to charge for this service. They were then told, no, you're supposed to charge this, which was more. Okay? And they said, well, no, we've been in the business for a while, and hearing aids, this is what we charge. They said, no, this is what you're going to charge because this is the charts that we have, or whatever the process was. And so the agency tells them to charge more. So time passes, right? 2, 3 years pass, maybe longer. Then you come around and you go to them and say, we're charging you with fraud. Say, wait a minute, what do you mean charging us with fraud? Well, we're charging you with fraud because you're being overpaid. To which those small businesses all said, wait a minute, we went to the agency and we told them that this is what we thought we should charge for the hearing aids and for that service, and we were told to charge more. And your office says, well, no, y'all committed fraud. So the legislator or one of our colleagues gets understandably responding to constituents, goes and meets with your office. Your office looks at it hard, he lays it all out, and then your office says, well, you know what? It wasn't intentional fraud, it was unintentional fraud. Now, does that make sense to you?
I'm not exactly familiar with the case you're referring to.
Well, do you remember hearing about people in the hearing aid industry that you charged with fraud?
Well, if you're saying we looked at the record and thought there was a credible allegation of fraud, yes. We don't charge anybody with fraud. That's a Medicaid fraud control unit process.
You went to them and you said, you've committed fraud. We're going to go after you now because you've committed fraud. Do you remember that in the hearing aid industry?
I remember those cases, yes.
Do you remember, could you just enlighten me, or maybe all the committee members, in the end, what happened? Because it seemed to me, in that case, that it's a wonderful example of how someone in the private sector trying to follow the rules, and they're told, these are the rules, and you follow them. They follow them. Then 2 or 3 years later, the left hand, this was the right hand talking to them, right? Then the left hand comes over 2 or 3 years later and says, no, we're going to say you've committed fraud. So well, tell me what happened. Tell us what happened.
Here's what I recall about those cases, Representative Raymond. You're right. We came in after the fact. We were not aware of any communications that they'd had with anybody in the agency. When we were made aware of those communications, you're correct. We indicated that there's no indications now that there was intentional fraud. However, based upon the program, there was an overpayment that had occurred in the hearing aid program. As we had those meetings, as I recall correctly, and Commissioner Janik is here as well, we determined that we did not pursue those cases or recover those dollars because of the fact that the providers had gotten feedback from agency representatives. So that's how those cases turned out.
Okay. So, but it took the intervention of a legislator because you guys weren't backing off. And it took the intervention of a legislator to go and say, wait a minute, this isn't right.
Well, I think the provider hadn't provided any indication to us, any documentation where they got that information from the agency. So to the opposite of that, we came back
I doubt
off.
that that's the case, with all due respect, Mr. Wilson, because let me tell you, generally, when my experience has been 20 years being here, you know, when people are dealing with government, they don't come to us until they've run into brick walls with you guys. That's when they come to us, okay? So, and I'm sure if the representative was here, he could verify that, because that's what he told me. Similarly, when I asked you about the Xerox contract, ACS Xerox, we've talked about that in my office, you and I have.
Yes, we have.
You told me, based on your experience, that you would consider what they did before the lawsuit was filed. Actually, the last time we talked about it, it was shortly before the civil lawsuit was filed by the Attorney General. And I asked you, based on your experience having worked at the Medicaid Fraud Division at the Attorney General's office, I asked you, what do you consider, how would you, everything you know, is this a criminal case or is it a civil case? You looked at me, you said, it's criminal. What these guys did is criminal. You recall that?
I don't recall making a comment either way.
Wow. Well, I'm glad I recorded it, so let me play it for you.
Okay, play it for me.
I didn't record it.
I'd love to hear it.
But you did tell me that, buddy. I asked you.
I know that we made a determination whether that was fraud. I think your question to me was, what I recall was, you asked me, did I think the providers committed fraud in the program, and did we have a cause of action? I said I thought we had 2 causes of action, both against the TMHP and against the providers.
Yes, I asked you 2 things. One was whether you thought that the contract and what the people who were supposed to be performing the work, whether that was just straight up, you know, a civil case where they should pay the state back, because this was before the lawsuit was announced, but it was shortly before the lawsuit was announced. We knew that it was being contemplated, right?
That's correct.
By the general. So we knew that was being contemplated. So I asked you 2 things. One, I said, do you, based on your experience, do you view this as a civil case or a criminal? You said, I view it as a criminal case, but that's just me, based on my experience. The second question I asked you was, even understanding that they were not doing their job of reviewing the cases that were being given to them, right? Do you believe that not only ACS, Xerox didn't do their job? You said, no, I believe they didn't do their job.
Correct.
But do you also believe, nonetheless, that the doctor who submitted a claim that was approved and that you later feel like you determined it was unnecessary, do you believe that that doctor committed fraud too? And you said, yes, I believe they both committed fraud. Both the company that wasn't checking the claims that was supposed to, and the doctor that submitted. That's what you told me.
Correct.
But
Representative Raymond.
Yes, ma'am.
I love this discussion.
Well,
can you get into the
I'm
recommendations
gonna-
of Sunset and whether they are...
I'm going to end it right here with
Okay,
this.
good.
It's important to me. I think it's important in this process, is that, you know, if it is your position, the position of your office, that that people in the private sector who are following the rules as they are told to follow the rules, right? In this case, now let's talk about the ACS Xerox contract. People who are submitting claims following the guidelines that we told them to follow, they submit it, okay? It is approved. We think, you believe it was approved because they weren't even looking at them, right? And that's what you told me. They were approved because they weren't looking. If they had been looked at, you believe that they would not have been approved. So what I want to say is, if those doctors who submitted claims that were never reviewed, but you believe were fraudulent from the get-go, from the time they submitted them, that those doctors knew or should have known that those services should not have been provided. If they didn't, I mean, if the doctors, if we're holding these doctors accountable, even though they followed the rules, they submitted it, then why aren't we holding you accountable or other people accountable for continuing to allow a company that was committing that fraud on the other end of it? I mean, if those doctors couldn't see what that company wasn't doing their job, and you're holding them accountable, shouldn't we be holding you and your office accountable because you didn't see that they weren't doing their job either?
Well, actually, I think OIG saw they weren't doing the job in 2008 and issued an audit report regarding TMHP and their lack of oversight.
And what happened?
For the agency didn't act. With regard to the providers, I think what our conversation was is if the providers actually submitted prior auth forms to TMHP, that they submitted in good faith that the clients actually deserved the service, then I would agree with you. But if they're sending in forms that they knew did not meet the scoring criteria of 26, and they sent it in anyway, knowing that TMHP wasn't looking, then they're not acting in good faith in submitting claims or prior auth forms to the contract.
But how do you determine that, man?
By the consultants that we utilize, and my dental officer that works for the Office of Inspector General, who's looking at the teeth of the kids
so
and
you're
the
convinced that
X-rays and all those things.
So you're convinced that every time a doctor sent something in, it didn't meet a 26 score, that they were intentionally committing fraud?
Well, what I'm telling you is the forms came in that, based upon the experts that we're using, to include our own dental expert, in many cases, 3 or 4 of the dentists are saying this kid did not meet the definition for Medicaid orthodontia, and in many cases, it didn't come close to meeting. If you look at the pre-treatment teeth on the kids, they look better than mine.
Well, what I'm telling you is that I am convinced from what I've seen that some of them were closer calls than what you're saying. Might not have been 26, might have been closer. But I'll end it with this because I know we got to move on to other members. But I got to tell you something. And you just said we found out in 2008 they weren't doing their job, and yet here it is 2014, and it took that long for you to get rid of them. How does that?
For me to get rid of them? They're not the OIG's contractor, Representative Ram.
Did you tell anybody that they should?
Yes, we did. We told the program.
Who did you tell?
We told the program.
Okay, can we move on? There's a whole bunch of people who want to ask some questions. Representative Dr. Buckingham.
Oh, thank you, Madam Chair.
Mm-hmm.
And Inspector General, thank you for coming to speak with us. I know you're in a
Yes,
bit of a
ma'am.
hot seat today, and that's
Yes, I am.
not comfortable, so we appreciate your speaking. So pursuant to kind of some of the earlier questions, it does seem there's some confusion, especially on the part of providers about, you know, what are the requirements as far as documentation and medical necessity and all that kind of stuff. And can you tell me what your office does to help educate providers that those mistakes can maybe be prevented?
That's something that comes up on occasion in the educational piece, and I absolutely believe my office has training responsibilities as well. But I think the main training responsibility rests with the Medicaid CHIP division, whose contractors these providers really are. They're contracting with the Medicaid CHIP program. Our office can actually train in terms of the things that we're looking for, which should be the same kinds of things that are required by the Medicaid CHIP division that they have in the TMPPM, Texas Medicaid Provider Procedures Manual, and that they have in rule with regard to how Medicaid operates. But while my staff can talk about what you can expect when OIG gets a complaint or we do data mining and find something that we're going to look at, what your experience would be with the Office of Inspector General, a lot of the training about how the program operates should be coming from the program, not solely from my staff. We should be echoing that training and actually attending the trainings that they put on. But right now in the contract for Medicaid, there's nothing that says that if OIG holds a training and I hosted in Dallas that they're required to attend. They have no relationship with me like that.
Okay, because on the self-evaluation report, it said that within your office, you have a job of educating the public and the provider community of ways to prevent, reduce, and report fraud, waste, and abuse.
Correct.
So can you tell me how many of your employees are actively involved in this process of providing education?
We have a lot of various nurses, auditors. I have a training guy that goes. Normally what we do is my dental officer has done, I don't know, a number. She can tell you what the number is. And so is my medical officer. We are invited to various trainings that associations are putting on. We're asked to train about OIG, stuff we expect in dentistry, things we do in nursing facility reviews, stuff we do in investigations. Anytime we're invited to attend a training for an association, we'll attend the training and put it on. We have a list of the trainings that we provide. I'll be happy to share that with you.
Okay, so you have dedicated staff who are doing that then?
Pretty much, yeah. Pretty much all staff at OIG, we have PowerPoint presentations that we utilize and a huge library of what those presentations are, so staff can go to them and pull from them if they need to, etc.
Okay, and can you kind of help me with the roles of the medical and dental directors and their status of their employment with you?
Yes, my dental officer is Dr. Linda Altenhoff. My medical director is Dr. Steve Rowe. They're both in the room. We picked them up as a result of Senate Bill 1803, and so both of them review, the dentist, of course, reviews dental records. She sometimes does in-mouth exams, let's say, on kids for my staff and or for the Medicaid Fraud Control Unit. She'll review charts and records when we pull statistically valid random sample from a dentist, etc. She does trainings, as I just spoke to, and so my my medical officer does the same thing. He'll review charts from nursing facility reviews or nursing or hospitals, etc. And my nurses and investigators can utilize them whenever they need to when they're looking at a case that fits within their expertise.
Okay. And can you help me, when are you required to impose a payment hold if you identify a program violation versus not?
The federal law for a credible allegation of fraud indicates that we're required to place a payment hold anytime there's a credible allegation of fraud that has an indicia of reliability from any source, which can mean it can come in as a complaint in our hotline, online on our website. It could be a phone call to us. It can be from our own data mining, etc. But when we have something that looks like there's a credible allegation of fraud, and the Sunset Commission referenced the TAC and our rules that govern how we define fraud in the state of Texas, those are the guidelines that we use to determine where we think something has risen to the level of a credible allegation of fraud hold.
Okay, and can you kind of just give me some ideas about what constitutes a program violation, just to clarify that a little bit?
Program violation can be anything that is inconsistent with the program. You're supposed to have a signed certificate of medical necessity in the file for a DME provider, and you don't have one. That's a program violation.
Okay, and are you required to impose 100% payment holds once you find a program violation?
So the way the credible allegation of fraud hold works, the feds, and we've gone to trainings on this since the law passed, and we've participated in it. The Medicaid Integrity Institute, which is a U.S. DOJ training ground for Medicaid program integrity directors that we attend often. The feds have not put what I'll say is an acceptable level of fraud in the law at all, so that if I'm looking at claims and we pull 150 and there are 5 or 10 where you billed us for something that you did not do, that would be credible allegation of fraud hold. They don't say, well, some level of fraud is acceptable, continue to pay them at this level and hold the other amount of money. If they think fraud is being committed, it's a credible allegation of fraud, the payment hold goes on. Now they do give exceptions for putting the hold on, things like if the provider is needed and it will cause a disruption of services in the Medicaid program, then you can talk about whether or not you have to keep them in the program and maybe do a limited hold. So there's exception criteria in the federal law that we can consider. One of that criteria, though, is not whether or not it's a financial hardship. That's not one of the things they contemplate in the law.
Okay, and then last question. So there seems to be, can you kind of clarify, there's what's identified as a potential overpayment versus the amount that's been deemed a final overpayment or a settlement amount? Sure.
A few years back, even when I was with the Medicaid Fraud Control Unit, so they'll send even notices to me when they do their work, and they're titled potential identified overpayment. A lot of that came into play because a few years ago, several years ago, the feds determined that once the state agency, any state agency, determined there was a final overpayment the clock for repayment to the feds began to run. That clock used to be 60 days. 2 or 3 years ago, they changed it to 1 year. From the time the state agency determines a final overpayment, you have 1 year to return the federal share, unless the provider is out of business, bankrupt. They give some rules where you don't have to pay the money back. So what pretty much all states began to do up until the final notice is if we identified an overpayment due, it became a potential identified overpayment until we had time to do what in Texas now is a informal review meeting, determine if we really know the final dollar amount, and then once we arrive at the final dollar amount and send that letter out, we know the federal clock begins to run from the time that final notice goes out before we have to pay the feds their share.
Okay, thank you.
So that's the distinction.
Representative Dutton.
Thank you, Madam Chair. Let me ask a question about your extrapolation method.
Sure.
Which is what I want to talk about a little bit. Tell me about that. Do you apply that, or when do you apply that?
So extrapolation, Representative Dutton has been around since the late 70s, but definitely the 80s when I came. Began doing this work as an auditor just for the Department of State Health Services, which used to be TDH. Basically, the concept is this: anytime you're dealing with a huge universe of claims, and so even the feds doing the audit of Xerox, you're going to find they're extrapolating to the state of Texas. But you're only dealing with a huge universe of claims that there's no way to look at all of them that you're looking at. So we're talking tens of thousands of claims, let's say. You would pull a statistically valid random sample, which is supposed to be representative of the entire population. Once you identify the sample, you go pull the actual records from that sample. You review and test those records. You develop an error rate, and then you extrapolate that error rate to the rest of the population, the rest of the universe, and you get a dollar amount associated with that universe that is representative of the errors that are in that sample.
Now the method,
or in that universe.
The method that you use, who developed it?
Initially, it was a guy by the name of Bruce Truitt, I believe, for OIG, who used to work for the State Auditor's Office, and there was a system back then called RATSTAT.
Was he an economist or a statistician or something?
Statistician was his title for us, and we have statisticians on staff. Now we have actuaries on staff as well.
Has the method ever been peer reviewed by any?
So here's what I'm learning in this process. I've talked to other states because I know most of the Medicaid provider integrity directors across the nation. No one's had their process quote unquote peer reviewed. What they have had is when they go to the hearings on their cases,
right.
The opposing counsel will have their own actuary or statistician
right.
who will look at your processes, and during that process is when you determine if they think there are errors with what you've done or not what you've done. And so our processes pretty much work the same way.
So have you had to defend yours in a court of law?
We've had to defend ours in our cases, yes. Keeping in mind, OIG has not had very many hearings on these cases at all, and we've had no overpayment hearings. We've only had a couple of CAF hearings.
What do you attribute that to?
Which part?
The lack of hearings.
My answer to that would be the current process that we have. We have the ability for a provider to request a CAF hold hearing and or an overpayment hearing. Once you request that hearing with SOA, then you have to wait until they set it. And if they give you a date, our experience has been providers can ask for a continuance, and then it gets set back another 6 months or longer. I think today if we ask for a hearing, what we're being told is the earliest we can expect is 1 year out from the day that we asked for it. So a lot of it is just how the process today works. We haven't had many, like I said, we've had a couple of overpayment hearings and a couple of CAF hold hearings, but no overpayment hearings. We've had one overpayment hearing since I've been there.
Really? Okay. And are you a lawyer?
I am a CPA.
CPA, okay.
And you asked the question about the requirements, and so I'll help you with that.
All right.
The Federal Inspector General Act of 1978, which is where a lot of this stuff came from, actually talks about the requirements of the Inspector General.
That's in federal statute?
This is in federal statute.
Okay, because that's why I asked, because I didn't see it in the state statute.
Yeah, this is in federal statute, and what it says is, appointed by the President with advice and consent of the Senate, without regard to political affiliation and solely based on the integrity and demonstrated ability in accounting, auditing, financial analysis, law, management analysis, public administration, or investigations.
Okay, all right. And so we follow that same guideline, I suppose?
That has been my understanding,
Yeah,
yes.
yeah.
So many of my counterparts in other states are either CPAs, lawyers, investigators, etc.
Okay. And other states, do they use the same sort of extrapolation method
Yes, they
in
do.
making findings about fraud or
Yes, they do.
overpayments? What's the, and you said none of yours has been challenged in a court, but you may have had some, I guess, in the SOA hearings?
I said we haven't had any overpayment hearings for the statistical sampling.
Okay.
Methodology has really been tested. We've had some questions from others from our statistician in a case, but those have been cap hold hearings, not overpayments.
Okay.
We've had one overpayment hearing that I'm aware of that we prevailed on. A total of $2.1 million in extrapolation was used.
Now, overpayment hearings don't get to SOA, right?
Yes, they do.
They do.
They can't get to SOA. The provider has a choice, SOA or HHSC appeals.
Okay, and if it's a fraud case, it automatically goes to SOA, does it?
So I think there's a little confusion about OIG because it talks about we investigate fraud, waste, and abuse. So a part of a case we'll work may involve some fraudulent claims, and a great part of it's going to be claims that are just program violations where there's been an overpayment identified by the OIG. The Medicaid Fraud Control Unit is responsible for pursuing fraud in the Medicaid program. We cannot pursue that
statutorily. So you don't
statutorily.
pursue that at all?
Not statutorily, not for a criminal prosecution. We pursue it for the overpayment that may be due back to the state, but not for criminal prosecution. We cannot.
Or are there any of your cases or claims that don't get to SOA?
As in, if they don't request a hearing at SOA, yes.
That would be
There's
the
some
only
where
way.
we settle.
That would be
But
the only
otherwise,
way.
if it's a contested case, it's going to go to SOA unless they choose to go to HHSC appeals. It's their choice.
Do the people who, or entities that are exposed to this extrapolation method, do any of them have the right to look at the method itself? I mean, do you provide them
Yes,
the
which
information?
leads to the issue of the actuary. What we do is pull our sample, investigator pulls a sample, it's validated by an actuary. Once they validate the sample, then the investigator goes out and pulls the records. The records come back in, they're looked at by a consultant. After the error rate comes back in, the investigator extrapolates to the population. That's validated by our actuary. After we do all of that and we know what we have, once we engage with opposing counsel and they have a statistician that wants to look at it, we allow them to reproduce the sample, the initial sample that we have, so that they can go through our process and look at how we arrived at not only the sample but the extrapolation around the sample. So yes, they're allowed to recreate it on their own without us. That's the idea.
Well, let's talk about finally the I guess he was a statistician in your office, the one who now has been accused of fraud himself or herself. I don't know if it's a male or female at this point. The cases or the individual claims that that person worked on, have you provided that same information in terms of what claims may have been subjected to this person's fraud?
We have, the investigation's ongoing, so I can't talk much about the investigation. We are aware of the cases where he was involved, and I'll say again, it wasn't our process for the initial sample and the extrapolation was fine. It was in our ability to recreate the sample for another party, for you to go back behind us and look at it. So it's a process whereby when we create the sample, we keep a seed value. That seed value allows us to recreate the exact same sample we pulled when we initially pulled the sample and did an extrapolation. Our guy wasn't able to find that sample and then got creative, and so that's what's being investigated.
When you say got creative, you mean he just sort of, rather than using what we used to call the swag method to do it, and I know you know what that means. Right?
I know what you mean, sir.
Right, okay. But so that's, and you said that's an ongoing investigation, but my question had to do with whether or not the companies that might have been subjected to this, were they ever notified?
Yes, there were. I think I sent a letter out to the entire legislature indicating that we identified 18 cases thus far. 9 of them had not moved beyond our office. So in some cases, the provider wasn't even aware that we had extrapolated what the dollar amount was. There was another 9 that they did know. Those providers involved have been notified. We're just going to pull another sample and start over.
And so they know. How do you go about selecting which company to take a look at? Is that based on some sampling also?
So prior to the new system we have called Torch, we had a system called the Medicaid Fraud and Use Detection System, which was predicated upon targeted queries and models that we built, etc., which identified outliers for us. Then, of course, as I said before, we run a hotline, 1-800 number, so people can call in with complaints. As well as online, you can get online and register complaints with the OIG, or you can write us letters. There's a number of ways to get us complaints. So it may come from a hotline, it may come from data mining, it may come from our new system called Torch, and it may come from initiatives that we've had. Like when we realized there was a problem with orthodontia, we began to look at orthodontic claims and dental claims.
And lastly, Madam Chair, one of the reports, or at least one of the elements in the report we have before us indicates that you were doing background checks on providers who had already had background checks over at the licensing agency. And I think I think if I understood your comment to that was you felt that the federal law required you to do them despite the fact that they had been done prior by the licensing agency.
Correct. The way, so I talked about trainings we go to in our office. There's a U.S. Department of Justice has what they call the Medicaid Integrity Institute, which is for all MPI directors across the nation, and they cover all the costs for you to go to this training on the University of South Carolina. Very nice training facility. But anyway, we train on all these different topics. One of them is ACA requirements regarding provider enrollment. That is something that is assigned to the agencies that we're responsible for. Some of the issues that we were having with relying on some of the licensing board information was they weren't required to share any of that with us, because as you can imagine, they're doing some criminal background checks on some of their enrollees, and they weren't required to share that information with us at all. Not all of them were indexed, meaning if the person had committed a crime in the last 2 or 3 years, would they know about it and then notify us. So yes, we were doing our own background checks on all enrollees or people, applicants into the Medicaid program.
All right, thank you, Madam Chair.
See, Representative Price is next.
Mr. Wilson, something you said, I just want to follow up real quickly on an answer you gave to Representative Dutton with regard to the due process procedures available to providers who are facing an overpayment determination. And I thought I heard you say that those procedures were the same for everyone, but I had I believe read that that's not true for pharmacies. Do they have the same due process mechanisms?
That's vendor drug. Vendor drug has a different process for their provider types, yes.
Okay, so what's the difference and why is there a difference? I mean, my understanding is they don't have the ability to go to SOA.
It's the way the vendor drug rules are written. There's nothing to do with my office.
So that's not a determination you'll make? It's
not a determination made by the Office of Inspector
But there is
General.
distinctions between the providers and the vendor drug?
And the vendor drug, yes.
Okay, all right, thank you.
Senator Schwartner, then Representative Perkins.
Thank you, Madam Chair. Mr. Wilson, I'd like to follow up there on Vice Chair Price's issue about due process.
Sure.
You keep mentioning there's a bottleneck in reference to these cases getting to SOA and having a findings of fact and law and return to the HHSC, not to mention the issues of HHSC's potentially changing those findings of fact and not actually ruling based on the SOA's ALJ. But is there a bottleneck at the OIG or at SOA, or where is the problem occurring to where these providers can't get finality in reference to the concerns in reference to CAF holds and payment holds that go to SOA?
and I may need to ask my general counsel, Joy Sparks, to come up here for a second. Here's what I can tell you. We are, from our perspective, I've instructed my guys not to ask for a continuance when a provider asks for a hearing either on a CAF hold or, we haven't had no payment hearings, but a CAF hold or no payment hearing. So while the law says that when providers request one, we're required to schedule it with SOA, we do that. Beyond requesting it, we don't control when the case is actually set for hearing. And so a provider asks us to set one, my guys will reach out to try to set it. We'll get a date from SOA, and then in many cases, there's a continuance that's requested by the provider, and then the dates get set back, and then so I kept a board in my office where I would write down all of our pending SOA hearings, and all I was constantly doing was having my executive assistant change the dates because it kept getting pushed back. And
You're telling me it's a tactical maneuver by the attorneys of the providers to lengthen the SOA hearing?
I don't know what it is. All I can speak to is that it's not happening. They get pushed back, and it's not getting pushed back by the Office of Inspector
Does
General.
your assistant here concur with that?
Let me clarify one thing.
Would
All
you state your name?
I'm sorry,
Please.
Joy Sparks, Deputy Inspector General, Chief Counsel. All payment hold hearings go to SOA. And there was a question a while ago, and I'm going to clarify that, on the cost. It was part of Senate Bill 1803 last year when we put the fiscal note on Senate Bill 1803, because we're not part of SOA's general appropriations, so we pay SOA. So like the last payment hold hearing we had about 2-3 weeks ago, we had 3 SOA judges assigned to us. It lasted for a week. So we pay $100 per judge per hour. So that's the kind of fiscal note we attached. It was a huge fiscal note when we were going to be required to go to SOA for all these hearings. So as a compromise, the provider said, okay, to help with some of this fiscal note, because the legislature's going, we are not going to incur that kind of cost. They said, we'll agree to pay half those costs. And so that was a question that was asked a while ago for the cost. OIG did not ask for that cost on that bill. In the payment hold process, they get 2 hearings. They get a hearing on the payment hold, all of them are at SOA, and then they get an ultimate hearing on the overpayment hearing. And they have the option of going to HHSC Appeals, which is free, or they have to go to SOA. And if they choose to go to SOA, they have to help pay the costs. So what happens, and in SOA's defense, these cases take a large amount of time. So they have a very full docket. So when we ask for a hearing, SOA has to try to figure out time. And then like in the payment hold hearing, they assign 3 judges. So you're trying to coordinate 3 judges' dockets. And then that's just on the initial setting, and that's not counting any continuances on the payment hold hearing. And then the payment hold hearing, whatever the decision is, they have a right to appeal. And so that's what we've done in the payment hold hearings. 2 payment hold hearings we've had, they've gone up on appeal. And so that's where they sit right now. Then they get an overpayment hearing. And the overpayment hearing can last 2 to 3 weeks. So we are currently, if we ask SOA for a setting today, we are out to a year from now. And that's on the initial setting. And that's no
Because
fault.
the workload of SOA is what I'm hearing.
It's a large workload, and it's hard to educate them on Medicaid claims, and so it's.
Madam Chair,
I think
Yeah.
Senator Hinojosa wants
it's
to
along the
just
same
insert a
line, please, go ahead.
clarification. Same
May I-
issue. Do you mind, Senator Swartman?
Sure, certainly, please.
Go ahead, Senator
what
Hinojosa.
you're saying is completely incorrect. So is not the problem. And let me read you from the report, okay? Cases languishing. Cases languish for months to years, stuck in various stages of the investigative and sanctions process. The OIG caseload consists of 1,156 cases, 382 of which are more than 3 years old, a backlog dating back to 2001. Few cases resolved. Because cases are not efficiently investigated, OIG takes action on very few complaints. In fiscal year 2013, OIG established overpayment in 12 cases, including 11 settlements and 1 default. This represents only 2% of the complaints open in intake for preliminary investigation this same year. So your response to Senator Schwartner is incorrect. So is not the problem, okay? That's not where the backlog is, and that was his question.
Well, what was it? The question was the
That's the right
juggernaut.
question.
The juggernaut can be many things. When we get to hearings and when we put payment holds on, which we've done on about 200 since 2011, that's when the hearing process begins. And then we are behind. I mean, our cases take 3 years.
3 years.
Wow. They were 4 years, now they're reduced down to 3 years.
And so, Madam Chair, if I could speak to the timeline on the cases that Senator Hinojosa referenced. Sunset was absolutely correct. As you know, when we talked about, initially I want to say in 2013, we talked about our time frame for working cases was over 48 months, as best we could tell, because we didn't have a case management system, long time frame. If you consider that in 2011, we talked about completed 12 investigations with a tune of about $27 million. Then the next year we did 108 cases and then 70-something other. If you consider we're referring back then from, I want to say 04, 05, 06 forward, over 200 cases to the Medicaid Fraud Control Unit, over 200. But in 11, we're completing 12. That is a huge backlog of cases that the Office of Inspector General absolutely has to work through. At that time, before you guys gave me additional resources, and actually in 13, when I just transferred people from our General Investigations Unit over to Medicaid provider, because I knew we had a huge caseload with 19 investigators, and we increased that prior to you guys giving me additional resources last session. When you have a backlog that long, it takes time to work through your backlog of cases. So we're down from over 48 months down to 3 years. But if you look at those cases completed in 13, which the report lays out, only 5 or 6 of them were actually opened in 13, and the rest of them did date back to 2004, 2005, 2006, because there is a backlog of cases. My backlog is no different than any other investigative agency, and until I got the resources to begin to work through that backlog, it was only going to get worse. We're getting a ton of complaints, and we didn't have the staff to work those complaints. So yes, we do have cases, historical cases, some of which were good cases, that we didn't have the manpower or woman power to get to. And so we're still working through those legitimate cases that we should work.
Sorry, Senator Schwartz, I do want to clarify that. Thank you.
Senator Schwartz, go ahead.
Yes. Moving on to the best practices of your office and how you administer the investigations and then the extrapolation.
Sure.
The actuary that fabricated the sampling data, there's a process that your National Association recommends, an external review of extrapolation on a regular basis.
The Green Book.
But my understanding is, at least I've been advised, that your office does not have an external review of extrapolation and had not instituted that until this era, or this fraud occurred in your own office. Is that true?
So let me explain, Senator Schwartner. The Green Book is Social Inspector General puts out the Green Book. And yes, my office has, since I became IG, began to move towards Green Book standards. Here's the challenge.
We don't have Green Book standards now at the current time, even with what's happened?
We're implementing the Green Book standards, yes, so we are. And here's what I'd say. The AIG has the Green Book, and initially, I'm on the board for the AIG now, but their goal was to do those quality assurance reviews for states. Right now, they're doing maybe 3 or 4 per year. That's it. Texas is in the lineup. I talked about it when I was down in Newark a couple of weeks ago.
Have you asked them to move to the front of the line?
Yes, sir, I did. Yes, sir, I did.
I mean, we have a loss of confidence in your office, and I hear it from providers. I have to answer to newspapers about it. And we want an OIG office that goes after waste, fraud, and abuse,
Absolutely.
but does so in a methodical, appropriate, systematic fashion that is based on the best science and the best practices. And we're not seeing that. I'm not seeing that. Members, I apologize.
Don't
Madam-
apologize.
Madam Chair, I'll turn it over to Senator Hinojosa.
Do you have other comments? We've got another. Representative Burkett?
Well, mine's kind of a follow-up to their questions. Okay, so what I understood you to be telling, I don't remember which senator was asking, you said you had 5 or 6 cases you resolved in 2013 out of the backlog case?
They
Is that
were
correct?
opened, no. Of the 73 cases they referenced, there was a 3-year time frame. 5 or 6 of them were actually opened in FY13 that were completed in FY13. The rest was cases from prior years that we were working
How
through.
many FTEs do you have?
There is a reason why we have some.
For MPI?
Well, in general, I've got here that y'all have 774 full-time employees.
Yes, sir. Yes, ma'am. That's not all investigations. MPI has now 103, but used to have 19 until we got the increases from the legislature.
So you had 19, and how many cases were you going through when you had 19 per year? Were you completing
That's what
or
I'm saying.
investigating when you have
In
cases that
2011,
are
we went through
3 years?
12 cases, and then we've increased that since then. In 13, there was 108.
So that's 1 case per employee, is that what I'm hearing?
Actually, in 2011, there was less than 1 case per employee.
Why?
I wasn't there then. I can't really speak. I wasn't the IG back then.
Gosh, as a business person, that you couldn't run a business on that at all. So 11 cases for 11 employees. That's 1 case per employee. And now we've got how many in your?
And MPI has, I want to say, 103 now investigative positions.
And you have how many outstanding cases?
I can get you the number. There's
Okay.
a lot of cases still
What they've
pending.
told us is there's 1,156 open cases.
That's
382 of those are more than 3 years old. What do you anticipate being a reasonable amount of time to get those cases completed or closed or nullified if they're not?
We're now working on having the backlog worked through, hopefully by the end of 2015. We're working with my deputy for enforcement and working with our managers and staff to try to figure out how we can
So you've
work
increased
through
your
that
staff
backlog.
from 11 to 113?
19.
From 19 to 113, it's still going to take a year and a half to let
103.
these businesses know if they've been, if they're still under investigation for fraud.
We'll do the investigations, but it does take time to work through a case. You're right. I mean, the timelines that we're expected to work these cases under, and then we're dealing with consultants having to review the records. Those cases take some time to work
So you
through. We
have-
got new cases coming in, exactly.
Sorry, I didn't mean to interrupt. So you have
That's right.
consultants as well as your 119 employees?
Consultants to review medical records. So if it's like a dental case, we'll have a dentist that has to review the medical records. If it's a case involving an MD, we'll have an MD that has to review the medical records. Some cases my guys can work. If it's something a nurse can do, then we use our own nurses. But there are some of our cases that absolutely require an expert to review.
So what do you consider, and I'm not a medical person, but what do you
Sure.
consider to be a reasonable amount of caseload for these people that are in your office? Because this to me just sounds like it's way out of equal employees to caseload coming through. Does that question make sense?
Yes, it makes sense. The very things you're talking about are the things that we're now working through with our staff in terms of what is a reasonable case. Though we thought we could, work cases 120, 150 days. Now we're working with staff to identify what's an average caseload for an investigator to work through, and given all the things we have to do with pulling records and extrapolation, getting consultants, and with the consultants reviewing those records, so in that case you can work toward another case. Those are all the kinds of things we're working through now.
So your outstanding cases is still 1,100? Is that right?
I can get an updated number.
Okay,
They're
let's just
working
say
through
that
them, but I
your
can get you
outstanding
the numbers.
cases say it's 1,100. You've got 100 and some odd
3.
employees. So that's 11 cases an employee. Is that correct?
Roughly, yeah, you're right.
And I just don't think that's an unreasonable amount of work to get those results.
I'm not suggesting that it is an unreasonable amount of work. I agree with you.
So do you have a
And new
goal
cases
set
will be
as to
coming
when
in.
you're going to get them done that you think is a reasonable time?
Yes, we have my deputy IG and the directors and managers are working through the timeline and aggressively doing so. She had them all in town a couple of times now to work out the details on how we're going to work through the backlog and keep the new cases moving as well.
And how long have y'all been working through that? For that goal, to get through that timeline?
Oh, for a while now, yeah.
That's my concern. I guess that's what I'm trying to come across. I think that, and Senator Nelson, I think this gives us a perfect example of why we need deadlines for anything that we set up.
Oh, sure.
That's just taking too long in my estimation. Thank you.
Let's talk about deadlines for a minute.
Sure.
The sunset recommendation 1013 says the OIG should track basic performance measures needed to monitor the efficiency and effectiveness
Yes,
of
ma'am.
its investigative processes. And I asked my staff to pull up your annual reports for the last come for 2012, 2013.
Sure.
We had to go back. The last one we could find was 2011. Where are those annual reports?
I want to say it should be 2012. We have, go back to your performance metrics, we track about 123 different metrics across OIG. The investigative area has, for enforcement, has 33 metrics that they actually track. 11 in NPI, another 22 in GI. And so we're tracking a number of metrics, Madam Chair. And we also, of course, have measures that are in the investigators' annual performance appraisal as well, of things they're supposed to accomplish in conducting their work, in addition to them meeting with their managers, going over the workload and how cases are moving, etc. The annual report that we prepared, or used to prepare, was not a required report that we put out every year. And so we have been, as you know, working on our data analytics system, working to hire the new staff that we had put on board. So we've got a lot of projects in the Office of Inspector General that we have been working on and towards, while trying to move the cases along and getting cases to SOA.
Didn't we provide funding last session for a new case management system that was supposed to improve your ability to track?
Yes, ma'am, and we have been building the data analytics system and the case management system. They rolled out the case management piece for MPI recently. My guys have been trained on it. We're using it. The vendors in our offices even now, working with staff how they use it. And then I think IA is rolling out next. And so we have each area of OIG rolling out the case management system. But as big as we are, that process took some time with the data analytics system as well, with Torch.
Members, do you have any other questions? You have a tough job. I mean, we felt so strongly, and you've heard it from Representative Raymond, you heard it from Senator Schwertner. We expect you to root out fraud and abuse. That is your job. At the same time, your authority has to be used judiciously, because your actions not only impact the livelihoods of our health services, healthcare providers, but they impact access to services. And we are going to continue to look at the recommendations made by Sunset, and I think that there possibly should be there may be some modifications needed. With that in mind, members, I'm going to appoint just one more work group. This will be my last work group. Senator Hinojosa, you worked very hard on this issue last session with Senator Huffman, and did yeoman's work. I think we got some work left to do. So I'm going to ask you to head up a work group on the OIG, and members Campbell, Representative Raymond, I'll teach you to ask lots of questions, Gonzalez,
Can we ask some more?
nope, and Dr. Buckingham. And I would like for you to come back to us on specifically modifications 10 and 11. And Senator Hinojosa, if you wouldn't mind, I know Senator Huffman has great interest in this issue, and you worked so closely with her on 1803 or whatever bill that was. If you would include her in the discussion, just to make sure that we're taking her concerns into consideration.
That'd be good. She and I all of us work together on legislation dealing with due process. So,
and we welcome everybody to these work groups. I know Representative Simmons has been sitting down there and has provided great input. So yes, if this work group, same as the other, if you'll come back to us with your modification recommendations, thank you. Thank you for being here.